Good morning, Counsel.
Good morning.
You should know that the 4 justices that appear before you will decide this case as a quorum. So I will turn to Mr. Crouch for his argument.
Thank you and good morning, and may it please the court. Andrew Crouch on behalf of Mr. Teixeira, who appeals from convictions out of the Plymouth County Superior Court. This was a close case. It was one in which the trial judge, at the conclusion of the Commonwealth's evidence, stated, "I think this case is really about Mr. Leverone," referring to Olivio. He told 2 versions of what happened, and the case really depends on which version the jury believes. This case largely depended, as the judge said, on Olivio's testimony as an individual who, frequently lied to investigators during grand jury and eventually at trial. These lies are troubling, but also as this case gets forward, moves forward, as the trial judge said, it really is between these 2 competing narratives. It's between, the version of events that Olivio says and the version of events that other witnesses say. And in a close case like this, small mistakes are magnified, and those mistakes get amplified if they're repeated throughout the trial, and whether that is an evidentiary error, an argument error, or an error by the trial judge or the prosecutor. And when you pile them together in a cumulative nature, it requires reversal. I would start today with the first issue in the brief, namely the errors in both the opening statement and in the closing argument. So in terms of the prosecutor's statements, when we look at the opening statement, what jumps out, and none of this was objected to, I'll acknowledge that from the forefront, and so we're looking at a substantial likelihood standard.
Could I ask you a question, please?
Certainly.
Just to clarify something. Is there any question here as to whether or not the defendant was the one who killed or shot the victim?
I think that there are some competing defenses, and I think that, with the decision, and not to be too roundabout here, I think that there is some question. I think that part of the defense was that it was actually Mr. Busby. There was some suggestion that it was Mr. Busby who actually did the shooting, but I think the evidence largely focused on the defendant as the shooter in the case. And I think that this can get into an issue I was to discuss later with regards to the self-defense argument, but specifically with regards to this opening, looking at the opening statement, it's here where we immediately get see some of the problems in this case, and that is where the prosecutor, within the very first words that the prosecutor says to the jury, makes this statement, this forecast of the evidence that suggests that it is the defendant who mistook Keith Leverone, the victim in this case, for his brother Olivio. And I would suggest that while we certainly give a great deal of leeway to counsel arguing in opening statements, and that is sometimes that reasonable forecast doesn't come to fruition if a witness takes a Fifth Amendment or asserts a Fifth Amendment or decides not to testify. That's not the case here. There was no evidence to support an idea that the defendant mistook one individual for another individual. They are in different locations by the Commonwealth's evidence. They're wearing different clothing by the Commonwealth's evidence. There's no suggestion that they look the same. None of Olivio's friends even know who Keith is. And so it's under those circumstances that this is not a reasonable forecast of what is to come. And this sort of error cascades into moving into a closing argument error, where the Commonwealth just changes 180 degrees in terms of its direction in what the theory of the case is. No longer is it a question of, that the defendant mistook Keith for Olivio. It's now that the defendant specifically targeted Keith because he was Olivio's brother. This, again, this sort of wild shift demonstrates the sort of, the lack of strength in the Commonwealth's case, but also here, there wasn't any basis in the record to suggest that the defendant actually knew who Keith was, and let alone that he was Olivio's brother. The evidence that the Commonwealth points to, not at the time of trial when it's making these arguments, but on appeal to try to sort of backfill an explanation, is there's one sentence where Olivio is asked, how do you know, Mr. Teixeira? And he said, from around. And then he said, well, your friends? He said, sure, basically. No more detail than that. They don't say for how long, they don't say in what depth. What we do know from the evidence at trial is that nobody knows who Keith is, who's there. None of Olivio's crew know who were riding with him that night. Friends that he talks to at the gas station or at the 7-Eleven have never met Keith before. By the Commonwealth's own evidence, Keith never gets out of the vehicle. There is some disagreement in the facts as to what, there is one witness who says Keith was involved in the fight, but there's nothing to suggest that he was actually known and therefore targeted. And this, in a close case like this, this is fireworks. This is really damning evidence when we look at.
There was no objection to it. There was no objection to it, though.
No objection to it. Certainly not. And as we know from their standards here on both sides, but they suggest sometimes that objection is actually what causes greater damage here, because it doesn't allow the judge to try to step in, offer any kind of instruction.
Mr. Crouch, the Commonwealth doesn't have to prove motive, correct?
Does not have to prove motive.
So what we have is this crazy series of events where Olivio stabs the guy, and we have this incredible hostile turn of events, and the evidence seems to be that Keith doesn't play any role in this, but nonetheless, at the last event, Keith is shot. So whether or not it's a mistaken ID or retaliation, the fact remains that there's this incredible amount of animus between Mr. Teixeira and Mr. Olivio Leverone, and as a result of this, Keith Leverone is shot, correct?
That is correct. And I think that part of the problem here is that while the Commonwealth is not required to prove motive, they are required to prove intent. And here, in terms of deliberate premeditation, they're saying he shot him specifically because they thought that he was Olivio's brother. That backfills, while that may be called motive in some respect, it gives in an otherwise, the Commonwealth and, the Commonwealth and the prosecutor themselves say, I know you're probably asking, why did this happen? Why did Keith get shot? Keith got shot because he was Olivio's brother. There is nothing in the record to support that.
But if we have someone, what the reason why they didn't do it's unclear. If they raised a gun and put bullets into somebody, isn't that kind of evidence of intent?
Well, then this feeds into the second argument with regards to self-defense and some of the other underlying issues. This is, I think, as I said, sort of backfills the Commonwealth's argument, and it allows them to sort of answer the question that is the main question in the case. Was this just a mere firing, not necessarily accident, but just in response to the circumstances as somebody trying to get away, as somebody trying to stop a beating, to prevent further beating, or was it a targeted killing? It's a pretty substantial difference. And it's one that when we don't have a lot of evidence on either side, when the evidence is close, as the trial judge said, for the Commonwealth to come in and say something like this without any support in the record, this is not your average thing where it's just hyperbole. This is and then the jury is left with the question, does the Commonwealth know something that I don't know? Why was he targeted? He was targeted because he was his brother? That is something that I think could weigh on the jury.
And I don't want to distract you from your self-defense argument. We'll get into that. But did Judge Chin remark the case is close, or did it appear to be close because Leverone tells different tales?
Yes, and that was what the judge said. As I said,
but he's not saying it's close because we don't know what the intent is. He's not saying it's close because it could have been self-defense. He's saying it's close because Leverone, Olivio, is all over the place.
Well, the judge says that in part, but also the judge doesn't think much of the self-defense argument because, arguably he gets it wrong based upon, as an actual, abuse of discretion for getting the law wrong on, saying barber means mutual combat means we're done. Like, we don't have to have a conversation.
This happens at the, was it at the 7-Eleven, right?
Yes.
They were at the Hess before.
Correct.
These are well-known Brockton late night gathering spots.
Very popular. There are 30 people at that 7-Eleven at 3 a.m. Yes.
Right. So so at the 7-Eleven, it's a parking lot. Where's the retreat?
So at that circumstance, getting into that self-defense argument, and I'll talk about where the danger is to him earlier. But here, where the retreat is that we have to take into account, as you said, all of the crazy events that occurred that evening. And they start, it's not just this snapshot in moment in time of what happens at that exact second at the 7-Eleven, but it's what is in the defendant's mind based upon the entire rest of that night. And as you noted, an hour to 2 hours earlier, he is at a Hess station where one of Olivio's crew pins him up against a car and Olivio stabs him several times with a dangerous weapon. Then an hour, 2 hours later, depending on the timing, around just before 3 a.m., show up at another location. And here, I think is where the judge gets a bit confused. he says, Olivio comes up and by all accounts says, look, I'm here to fight. I'll fight anybody. He has this generalized threat, lifts up his shirt, shows he doesn't have a weapon at that point. And then he is then, as they say, thrown upon. And the Commonwealth tries both at the trial and later in on appeal here to sort of downplay the nature of the beating. But if we go and just talk, look at the witnesses.
Does it matter? Does it matter? Does it matter how bad the beating was?
I think it certainly does, because it gives the defendant an understanding. The defendant at that point, it matters for both of the first two prongs.
How did it go to the issue of the retreat? I mean, which is I think what Justice.
Sure. So at that point, he has been stabbed. He has now been beaten for because we keep this in the light most favorable to the defendant, and the bar to get that self-defense instruction is low, and judges are supposed to err on the side of caution in giving it. In terms of retreat here, he has been beaten. He got injured earlier. He's then been beaten for up to 10 minutes. And what the cases don't suggest that he has to, singularly retreat in every single circumstances. If the nature of the invitation to fight changes and it goes from, he assumes, I presume, he's going to fight one person as opposed to fighting all of Olivio's crew, which again, that is either 3 or 4 people, depending on who we're talking about. Here we're looking at 4 people in the light most favorable to the defendant, and we look at, as Attorney Galvin pointed out to the judge at trial, we're looking at the timing here. The timing is within seconds. Olivio himself testifies that he is maybe 10 feet away by the time the gun is pulled and a shot is fired shortly thereafter.
He didn't have a gun in his hand before, did he?
He did not have a gun in his hand before.
We had to get it from someplace. He got it from the other door.
Basically turned around and got it, and Olivio says, this happened quick. This happened.
Why wasn't that an opportunity to retreat instead of getting the gun? Why wasn't that an opportunity to retreat?
Because at that point, I think, based upon, and again, in the light most favorable to the defendant, framing it in light of what happened earlier on, the defendant does not know whether or not these individuals, the individuals claim, Olivio claims, fight's over. At this point, he is dazed, he's on the ground, he's been beaten for 10 minutes, he's been kicked in the head, he's been kicked in the ribs, he's been punched repeatedly, had his shirt pulled over his head. He doesn't know that the fight is necessarily over. These individuals may be moving back to a vehicle. He knows that they have had dangerous weapons earlier. In these circumstances, and it's not for this court or myself to judge whether or not that self-defense would have been successful ultimately at trial. The point is whether or not the jury should have been required, be given the opportunity to consider it. And
Can I ask you a question though about these vehicles? I'm really confused about the black Acura, which I suppose there was evidence as to, which that was the one that he had been driving, that Olivio had been driving.
Correct.
And the red Ford Focus, in which the defendant was later found. I thought that there was evidence, though, that the defendant took off in the Acura, the black Acura. So I don't understand the relationship between that and the red Ford Focus. Could you?
Sure. So the red Ford Focus is or the maroon car, as it's called, is the one that is used earlier in the evening, and that is one that I think at that point doesn't necessarily show up at the gas station. It's really the black car that is the one that is eventually, that is the one in which Olivio and his crew and Keith are riding, and eventually, the defendant leaves the scene and is able to finally retreat after the fight concludes and the shot is fired.
So the defendant goes into the Acura.
Yes, he actually has to retreat to actually get away from the scene. He has to leave in Olivio's car, the guy who beat him up. That's how he gets away.
And the victim at that point, though, was already in the car, right? He was in the car?
Well, this is a problem. And this is part of the problem with the Commonwealth's evidence here. And this is part of it from the closing argument. In the closing argument, the Commonwealth states, look, Keith was cowering. He was an individual. He knew that this was coming. He was dragged from the vehicle. There is no evidence in the record to support that. There are 30 people there. There are multiple people who testify at trial. Nobody has any idea how Keith got out of the vehicle. They do know
that he was shot from pretty close.
Well, the Dr. Hull is not able to testify as to what the distance is.
Not what the position is, but I mean, how close?
Also, it says that there aren't any actual any powder marks, nothing like that. Dr. Hull can't testify as to the distance and the proximity. So we actually don't know. And the Commonwealth tries to make a lot of this. The Commonwealth tries to say, look, basically he uses the phrase executed twice. Went from mistook in the very first words to the jury, and by the end it's an execution where the person is dragged from the vehicle and is cowering, knows it's coming, and is shot. There's no basis in the record for that. You won't find it in Dr. Hull's testimony. Indeed, the trial judge himself says that this is pure speculation and sustains an objection, doesn't allow them to testify, doesn't allow Dr. Hull to testify or the Commonwealth to raise these points because there isn't any basis in the record for it. We just don't know what position Keith was in when he was shot. But we do know that at that point, the defendant has to, when he is fleeing the scene, the way he's able to get away is in Olivio's car. So I would suggest his ability for retreat in that circumstance where he's been beaten by those individuals, we've at least, he's at least gotten over that low bar that required the giving of that self-defense.
By the time he gets into the car, I take it that the victim has been shot and he's on the sidewalk.
Yes, he's been shot. And as I said, all of this happens very quickly.
He's outside of the car though.
At that point he's outside of the car and he's able to get away from the scene based upon having, yes, at that point, indeed, Keith has been shot and is presumably laying on the ground outside of the vehicle. Again, we just don't know. There isn't evidence to fill in what happened there. And it's not even a basis for speculation. There just isn't any evidence on it.
When he's arrested though, when the defendant is arrested, he's arrested in the red Ford Focus, right?
He is arrested in the red Ford Focus, which was not at the scene, as I said. There is sort of a gap, which is, I think, the confusing part. It is used in the earlier scene where Olivio claims that even though it's cold weather or whatever, that Teixeira is leaning out the car window and popping off shots at him, even though the guy who's driving the car, Andretti, says, or is in the car, says that never happened. Then it is at the Hess. It is not then, that individual then basically, I think, leaves the scene, goes elsewhere, and then that car comes back into the fold the next day when it is pulled over by the troopers and then searched eventually. So in concluding with regards to the closing argument, just to finalize the argument there, there are, even though this is under the substantial likelihood standard, there are a variety of things that are said in this case where it is, as we've noted, basically two competing narratives of what happened. When the prosecutor inserts themselves and makes statements that are outside of the record in a substantial way, in a close case, I would suggest that this does rise to the level of a substantial likelihood. When the Commonwealth is saying that he intentionally executed Keith, that he was cowering and knew he was about to be shot, that he dragged him from the vehicle before shooting him, and essentially that the defendant started a fight with multiple people so that he knew he'd be able to shoot somebody afterwards, along with the Commonwealth's misstatement, the no basis in the record forecasting of what the evidence would be in the opening statement. I would suggest that when we put all these together, even under a substantial likelihood standard, there are problems here. And these are problems that rise to the level in a case such as this, that this is that unusual case that where that substantial likelihood standard is met. And just finally, with regards to the second argument and sorry to jump around here a little bit, but a lot of this is interrelated. When we take the evidence in the light most favorable to the defendant and we consider that low bar for entry, here where the trial judge mistakes the standard and says that standard under Barber, which I have to believe he's looking at the appeals court decision and not the Supreme Judicial Court's decision on Barber, and says mutual combat prohibits it, we know that that's not the standard. We know that that's not the rule. That we know that there's more substance to a discussion that has to happen, and it didn't happen in this case. So I'd invite this court to take a closer look at what that should have been. And as we note, this is not a situation where we are here to judge whether that would have ultimately been successful, but instead we know that the jury is the one who should have probably been allowed to consider, with all of these circumstances, as Justice Gaciano noted, these are crazy circumstances. This case is very unusual, happening in multiple different locations. And just briefly under 33E, this is not a case where—
Can I just interrupt you there, please?
Sure.
I'd like to ask a question about whether you can point us to any case where the defendant retreated from a fight to retrieve the weapon he then used in self-defense.
I think the cases that we can look at are, the best ones essentially are, let's see if I can The cases where I think we can draw at least the sharpest contrast, as opposed to ones that are necessarily analogizing to, because these are kind of unusual cases. You know, the ones like this where it happens like almost like that, like within seconds, according to Olivio himself. The cases that we look at are ones where an individual goes away for some period of time, gets a weapon, and then comes back, makes phone calls, things like that. And I don't have the direct case in front of me. I don't know if it was Barber. Well, I don't unfortunately have the direct case in front of me I wanted to talk about. But those are the cases where, you know, and I don't know if it's a case more along the lines of Pring Wilson, you know, where, or something along those lines. But the cases where we see the sharpest contrast are ones where the defendant leaves the scene for some period of time and then comes back with a weapon. And that's not what happened here. This is a contiguous circumstance that happens in the light most favorable to the defendant within mere seconds of this fight, you know, not necessarily concluding in the defendant's mind, but at least the last punch or the last kick having been received after a night of being abused, beaten, and stabbed and kicked by this same crew.
Thank you, Mr. Crouch. Mr. Wayne?
You have to unmute yourself, Mr. You have to unmute yourself.
Okay,
There you go. There you go.
may it please the court, my name is Mary Nguyen on behalf of the Commonwealth. This was not a close case. In fact, there was overwhelming evidence in this case that the defendant was the shooter. There was overwhelming evidence of intent and premeditation. There was physical evidence tying the defendant to the shooting. I point to the black gloves that were in a plastic bag with gunshot residue and DNA linking the defendant as a potential contributor, which were found in a plastic bag with the defendant's blood-stained clothing. There was testimony from other witnesses corroborating Olivio's testimony. So this was not a case where evidence that the defendant was the shooter was solely dependent on Olivio. Not only do we have that physical evidence to corroborate his testimony, we have testimony from Lydia Goncalves testifying that after the fight ended and everyone walked away, the defendant walked over to his companion and demanded the gun and retrieved the gun from his companion. That there's the surveillance video
Can I ask
from.
you a question about this, about the timing of this? Well, your brother says this was just like seconds apart. So what do you talk about the timing? Could you tell us about the timing of all of this?
Sure. So, so with respect to the timing, I think it's important to note, and especially with respect to self-defense, is that the defendant's combatants had walked away. The fight was over. And that doesn't come only from Olivio. That testimony also comes from Lydia Goncalves. The fight, for all intents and purposes, was over. The combatants had withdrawn from the fight, and the defendant was on the ground. He stood up. Then he walked over to his companion, Mr. Busby, demanded a gun, retrieved a gun, and then proceeded to run to chase Olivio. So with respect to the time, all of those actions were taken by the defendant in that span of time. So this is not a situation where the defendant was in imminent danger. There was no present threat at that juncture or no overt act by the victim or anyone in the victim's crew, if you will, at the time of the shooting. There was no impending harm. So any perceived threat ended when the defendant's combatants walked away.
Could you give me some sense of how far apart the black Acura was from where the fighting had been taking place, where they were beating up the defendant?
Certainly. So the Acura was parked in the second. I believe the evidence was it was in like the second lane, if you will. So it was in close proximity.
It was or was not?
It was.
Yes. Okay.
It was in close proximity.
How could he tell then that the fight was over if he was walking away to the car that was close by?
How could the defendant tell?
Yeah, how could he tell that the fight was over?
Well, the evidence from the witnesses were that the fight had ended. He was on the ground, and his combatants had walked away, heading to their car.
Okay, which was pretty close by.
Correct.
Okay.
And
So he has to race over to the car, in other words, in order to kill the brother?
The evidence was that, in fact, he was chasing after Olivia, and Olivia was running away. And why was he running away? Because the defendant had a gun.
And where did Olivia go?
Olivia ran towards Belmont Street.
Okay, which was away from where the car was parked, or toward where the car was parked, or what?
It was away from where the car was parked.
So the car was already there, was there while Olivia was running away, and then the defendant.
Correct, and seated in the car was Keith.
Right.
So Olivia testified that when he was running away from the defendant armed with a gun, he did see his brother still remaining in the car, still seated in the car.
So he was running away. He didn't run to the car, in other words.
He was headed to the car, and then ran past the car as he was being chased.
He went past the car, in other words.
Yes, he did. He did ultimately go past the car
Okay.
as he was running away from the defendant.
Okay.
And
The defendant, you say, shot the victim, and then got in the car and took off.
correct. And then there's
Olivia was watching all of that.
so the evidence was that while he was running, he did, and he was running back after he heard the gunshot. That he did in fact see the defendant taking off in his car. And then the next time he sees his brother is the brother's no longer in the car. He's on the ground with a bullet in his head. And then there's surveillance video in this case showing the defendant dressed in Olivia's hat and sweatshirt, which were inside of Olivia's car before the defendant stole the car and fled from the shooting scene.
What happens to that car, by the way?
So what happens to the car was not part of the evidence. The Commonwealth's motion to admit evidence that there was an arson with respect to the car was not allowed, so the jury didn't hear that evidence.
Okay.
But they did hear about the fact that it was recovered in Taunton, not too far away from Brockton, and that the defendant is seen on video approximately 2 miles away from where the car was recovered, dressed in clothing belonging to Olivia, which was inside that car prior to the defendant stealing that car.
What do we make of the inconsistencies in the government's theories about mistaken ID and retaliation?
So with respect to that, so as Your Honor had indicated, motive is not an essential element. It's not something that the Commonwealth has to prove. But I think that when you look at the opening, it was grounded in good evidence, given that all the evidence suggested that the animosity, the animus that the defendant had was with respect to Olivia, and that during the entire sequence of events that day, Keith was not involved. He was present but not involved. So certainly the prediction that the prosecutor made in her opening was reasonable. But with respect to the theory at the end, I don't think it matters so much that there was evidence, as I indicated in my brief, that the jury could infer that the defendant knew that Keith was Olivia's brother. But I think the more important thing is that there was evidence that Keith was part of Olivia's crew, if you will. So I think that the theory that the defendant was running after Olivia and chasing him with a gun and couldn't get to him, so he instead shot a companion of Olivia, is what's important.
Was there evidence in any way that the defendant knew that the car was Olivia's car?
I'm sorry?
Was there evidence that the defendant knew that the car was Olivia's car?
Yes, so in addition, so that's actually the evidence about the prior shooting on Warren Avenue. So Olivia was driving his Acura when the evidence was that the defendant was shooting at him from the red Ford Focus.
Was there another somewhat far-fetched argument that that the defendant allowed himself to get beaten and not have a gun, and then he did it to kind of lure them in. Isn't that wildly speculative and an improper argument?
Your Honor, I don't believe it was. I think that the jury rationally could have concluded, based on the evidence, they could draw this inference. I believe it was reasonable and possible for the jury.
That someone allows themselves to get thumped, and to make them unawares, then they're gonna grab the gun. That's not very logical, and it seems to me to be very far-fetched and improper.
I think the jury could have credited evidence that the defendant invited a fight with the knowledge that his companion had a gun, and that there was no indication that anyone else was carrying a weapon.
So he allowed himself to get thumped by 3 guys.
Because he knew he could use and intended to use the gun that was readily available to him.
So I think that's the problem, is if we sanction these things and prosecutors do kind of reckless arguments like this, right?
I think that argument was grounded in the evidence, but to the extent that there's a question about a misstep in the prosecutor's statements in that regard, the judge's repeated instructions with respect to closing arguments not being evidence was sufficient to cure any possible prejudice.
I'm kind of concerned too in that regard about the fact that the prosecutor argued something that the judge had really sustained the defendant's objections to in terms of the questioning asked about the expert doctor, medical examiner, as to when, how close the weapon had been, the angle of the weapon when the shot was fired, how the shot had occurred, what had been the victim's position at the time of the shooting, and so forth. And I thought that the judge was pretty clear that this was, the expert was not going to speculate or adopt some of the Commonwealth suggestions, and yet the prosecutor states in her argument as a suggestion, quote unquote, but none of them was really based on evidence before the jury. Where was it?
Your Honor, I believe that my reading of the record is that the judge sustained the objection with respect to the medical examiner, indicating that that would be speculation on the part of the medical examiner. But my reading of his reasons in sustaining the objection is that he thought that there was sufficient evidence before the jury for the jury themselves to draw that inference. And I think the fact that there was evidence that the victim was shot on the top of his head down, and that he was last seen sitting inside the car, then he's next seen outside of the car with a bullet in his head, that it was a reasonable inference for the jury to conclude that the victim was outside on the ground and much lower than his killer, so that he had to either be kneeling, cowering, squatting, crouching, or on his knees. I think that was a reasonable inference based on that evidence. And in any event, the jury did not appear to be swayed by that portion of the argument. The prosecutor in particular limited that argument with respect to cowering to the extreme atrocity and cruelty theory, and the jury simply rejected that specific theory and did not convict the defendant on that theory.
Can I ask you a question, please, about whether or not there's any evidence of the shooting had to have taken place outside the car rather than inside the car? Was there any evidence as to blood inside the car or anything like that?
So there was no evidence. There was no forensics with respect to the black Acura, because the jury didn't hear this, but there was a limiting instruction that there was no forensic analysis, because outside of the record, we know, or outside of the trial evidence, we know that the car was torched. But that was not before the jury.
Oh, I got it. Right. You said that. Yeah. Okay.
And so, and just continuing on self-defense, I had talked about the fact that the defendant wasn't in imminent danger, but even assuming that he reasonably believed that he was in imminent danger, he would still not be entitled to self-defense instruction because he had a duty to retreat. And I know this was touched upon in my brother's argument, but he failed to do so. The evidence was such that the defendant easily could have and should have walked away after the fight ended. He chose not to retreat, and he decided instead to walk only so far as his companion in order to retrieve the gun. And there was no evidence, as Judge Gaziano indicated, that the events took place in a store parking lot with ample open space for the defendant to retreat. So there was no evidence that there was anything preventing the defendant from walking away. There was no evidence that he attempted to retreat. instead choosing to escalate the situation he created. With respect to closing, I'll move on to closings. We talked a little bit about the closing, but with respect to I don't think I have anything further to comment on with respect to closing. Does anyone else have any questions?
No further questions, Ms. Nguyen. You rest on your brief?
I will rest on my brief. Thank you.
All right, thank you, counsel.